Hello to all of you and welcome. This is actually the first event we have had in our brand new headquarters, what I call, and I hope you will take the tour with us after, the Palace of Arbitration. So we hope that we will be able to welcome you here for cases, and we are delighted to welcome you for this event today. This is a terrific kickoff event for our new center because this is a very important new book that I think is going to make huge waves and have a huge impact in our field. As you know, Susan is the foremost empiricist in investment arbitration, and I think it's been so wonderful to see all of the things that we thought we knew or didn't know. Susan's been able to give us the numbers and say, actually, here's the way it really is. And I think this has really shed a lot of light in the discussion about investor state. And I know she has been working very hard on this book for a long, long time. The genesis was a while. The gestation was a couple of years, but she has done an extraordinary job, and I highly commend the book to you. So Susan is obviously our premier panelist today. Besides Susan is Christina Beharry, who is an attorney in international litigation and arbitration at Holey Foag, specializing in public international law and investor state and commercial arbitration. So Christina is here as part of our panel to comment towards the end. Towards the very end, we have Patrick Pearsall, who's the chair of Jenner and Block's Public International Law Practice and was previously the chief of investment arbitration at the U.S. State Department. And between Christina and Patrick is Mark Kantor, who of course is an arbitrator and mediator of commercial and investment disputes. He's an adjunct professor at Georgetown, retired from Millbank Tweed, where he was a corporate and project finance partner. And he's the one who sends those great posts for all of us, often with the warning long post, but they never fail to at least twig a great conversation. So another wonderful person, and we thank all of our speakers for being here today. What we propose to do is to have Susan, first of all, give us an overview of what the book's about and the main premises of the book and the main findings that came out of it. And then we'll take 2 to 3 questions on that. And then we had a series of questions for the panelists, and we hope that these will also inspire some questions from the audience. We very much would like this to be interactive. So please, if you have questions, put your hand up or please speak up. We also have a number of people joining online today for the event, and for those of you who are online, first of all, please place your mic on mute. And secondly, you will see in the lower right-hand corner there is a chat box, and you can send in any questions that occur to you as you watch this presentation. So let's get on to the meat of the matter. Susan, tell us about arbitration costs.
Thank you, Meg. It's really a pleasure to be here at these beautiful facilities, and I very much appreciate you welcoming me here and the hard work of all the staff in putting this together, and to Oxford University Press for being here to not just flog the book, but to make sure that it got published in the first place. I also wanted to thank you for giving up your time this evening, as I know it's a very beautiful day outside, and being able to have a drink of something civilized is a great way to end the day, but I hope that after this we can all enjoy some refreshments. And thank you also to the commentators for digging into the book and being able to comment tonight. I'm particularly grateful to have this event at ICSID, as we all know that costs are becoming a major part of the debate about international arbitration and its future. It's not simply that costs matter in terms of the UNCITRAL reform process, but certainly very much at the forefront of the ICSID reform process as well. And at the core of this book is really, it's about the kernel of psychology and what it means to test evidence to make sure that we're making evidence-based choices that are more likely to be informed and optimize dispute settlement in a way that works for its stakeholders. Costs have fundamentally become a proxy for larger debates about the system and investment arbitration, and we need to use this opportunity to think carefully, thoughtfully, and dare I say, in a balanced way, without rushing to emotional conclusions or cherry-picking information that conforms to our pre-existing beliefs and norms. Because we live in an age of social media, the Twitter universe, Google bubbles, and Facebook fortresses, as foreshadowed in a 2008 book by Farhad Manjoo called True Enough, and eloquently explained by Jean Twenge in her book, iGen. We are becoming more isolated from each other, more polarized in our thinking, less likely to find common ground. Generations of moderates are dying, and we are more likely to find thoughts different from our own to be a threat to our emotional safety. In many respects, our brains are regressing, and this impacts both our social and political discourse. Investment arbitration is in this crossroads. We find public exorcisms of international arbitration lawyers, commenters suggesting that investment dispute settlement is a legal monster that agrees to be sued by the devil in hell. Parliamentarians involved in physical altercations and Politico reporters have even made investment dispute settlement their favorite Halloween costumes. In other words, there has been an inflammation of the public mood, cherry-picking of various horror stories, and a focus on fear. On the other side, there has been a triumphalist narrative about the importance and the power and its institutional success, and we find ourselves in a moment where there is less balanced and data-driven analysis of costs and investment treaty dispute settlement and more of an appeal to emotion and truthiness. I know that by neither aligning myself with a pro-ISDS or anti-ISDS faction, I am both fighting against the current zeitgeist, and it also means that I will have minimal political cover in an era of tribalism. But in an effort to ally myself with data and understand that different perspectives can be identified by looking at data in different ways, my hope is that this book offers something for everyone, namely something to dislike, something to like, something to benefit from, and something to challenge us with, so that we can begin to test whether or not what we think is true actually is. One of the themes of arbitration costs is a focus on psychology and research by scholarship from people like Philip Tetlock. Tetlock was interested in exploring the quality of expert political judgment and whether or not experts were any good at making high-quality predictions. And honestly, this is one of the most interesting studies that I have seen in my time. But essentially what he did was he engaged in a longitudinal study where he sampled and tapped about 300 different experts in different areas across political and institutional experiences, and he put their predictions about the future essentially in a time capsule and opened it up 20 years later to see how good these experts were at predicting the future. 20 years after, when he did open that time capsule, on the whole, this is what he found. Expert political judgment was not necessarily any better than random guessing or a computer algorithm. Computers sometimes were better than experts. But if that is the end of the narrative, then you've actually missed the story embedded in the data. Not all categories of experts are created equally. There was one category of experts who was good at predicting the future and one who was not so good. The category who were providing quality were the foxes. The foxes who were better at understanding nuance, not necessarily being beholden to one ideological precept, but instead were able to take in the information that may not accord entirely with their worldview, and change and adapt and be willing to understand alternative ways of doing things. The group that was less quality in providing expert predictions were the hedgehogs, who knew one thing, who tended to go along with ideological groups. The irony of this situation is that hedgehogs, who often speak forcibly and predict with great confidence and get the spotlight, particularly in an era of social media, are rewarded for outspoken opinions, but are nevertheless more likely to be wrong. I want to encourage everyone today, if you leave with no other memory, to be more fox-like. or to be simply, be a little foxy. And that includes myself. The conventional wisdom on costs in particular is an opportunity to test what we think we know, to figure out what we think is right, and to figure out where we may wish to adopt so we are less likely to generate error and more likely to get the results that we are hoping for. So some of these conventional wisdom that I would like that the book puts to the test are that parties' costs are skyrocketing. The OECD indicated $8 million per case was the average costs. OECD and the European Commission suggest that it was $8 million per side. Ironically, they cited the OECD report, but they misread the information contained in it, and they literally cited the correct footnote, but nevertheless reproduced improper data. Commentators suggest that the costs are $20 to $30 million. Some people also think costs are addressed in particular ways. Lucy Reed, for example, suggests most parties pay their own way, whereas others say actually cost shifting is dominant. And again, I put myself to the test as well. In some of my earliest scholarship, I suggested that tribunals would shift costs to deter frivolous litigation. But the question is whether or not these assessments are underscored by the data. So in chapter 3, and I believe if Blake was here, he could tell you that there's the data set in the code book, all 130 plus pages of it, are now publicly available online, and indeed appendixes in the book help break this down. But the idea is generally that I was looking at public awards that were focusing on investment treaty arbitration, not national law litigation, not commercial litigation, but investment treaty dispute settlement. Thanks to a series of students, many of whom came from Washington and Lee, and I'm happy to see both WCL and WNL students here today. But in connection with the coding process, we went through a rather rigorous series of conversations where we had 95% intercoder reliability, and then we had hours and hours of coding meetings to make sure that we had an agreed code at the end of the day. But what that means with data current to 2012, which creates its own case selection effect, we had over 272 awards to analyze, and with the variables that we created, we had over 40,000 pieces of individual data. So that's the background. And of course, what you put in is often what you get out, but we can come back to that more later during questions. I want to have you walk into my world just for a moment of what are we focusing on when we're focusing on cost variables, because very often it is easy to blend different types of costs, but work with me, please. The first type of cost variable I want you to focus on are the parties' legal costs, which P for parties, that might be a nice way to distinguish it, and the costs of both the investors, counsel, and all the related expenses, and the respondents on related expenses. The second broad category of costs I call TCE, tribunal, for a T, costs and expenses. Includes administrative costs of secretaries, institution, etc. This book, which basically I was saying to Meg, I think for every 10 pages, every page of the book, I probably lost 10 to 20 hours of my life. Which it's a very long book. But the bottom line is I wanted to make sure that we considered things holistically so that we could be more Fox-like. We're going to talk tonight about basic, raw, descriptive pieces of information about what those costs are, when tribunals address those costs, and what there are links with outcomes, justifications, and a bit of the cost predictors. And again, if you want to read the book, buy the book, you're entitled to do that. But I want to hopefully give you a bit of a preview to make it easier to access, because I know the print is very small. And I understand it's easier to read on a Kindle because you can blow up the text a little bit. But let me try to help access the book in an easier way. How much does investment treat settlement cost on the basis of the data, again with its own limitations? Proportionately, the costs compared to itself were quite large. If you looked at outcomes in all cases about costs were a function of 60% of average amounts awarded. If you look at the smaller subset of cases where investors won, you're still looking at about 22%. So a little bit less than a quarter of the damage awarded. So this is a rather large proportional thumb on the scale. But if you want to get down to brass tacks in terms of actual averages, this is taught all together for the parties' legal costs, not the tribunals, were around 10 million, and this was in for both parties combined. But then you break it down per party, about 5 million for investors, about 4.5 for states, and this was in 2011 adjusted data. So these are not small amounts, right? They're very large pieces of cash. Adjusted for inflation, and this was quite interesting to me because people were saying costs are changing, they're shifting over time. The second that you adjust for inflation to make sure you're comparing apples and oranges and oranges, an interesting thing is that we can't actually find a reliable increase or a reliable decrease in either party's costs over time. But something is happening. We're just potentially misattributing it to the wrong variable. And where there is a shift involves cost shifting, which I think is interesting. So the average cost shift for parties' counsel is about 64%. And believe it or not, the physical amount of that cost is reasonably equivalent, including standard deviations, for both parties. But this is where there has been a small shift. It's not that the amount of counsel's cost increased over time. It was that tribunals' interest in shifting cost did reliably increase. So if you look at the oldest cases in the data set, tribunals weren't so interested in cost shifting, but if you look at the more recent cases, tribunals were much more interested in shifting those costs. So something is going on. The data did reveal a difference, but I want to make sure that we attribute it to the right factor. Tribunals' costs were proportionately small, a little bit less than 10% of the average party's costs and 5% or lower than the average amounts awarded. So it's important, but it is not proportionately as large. When you look at it in terms of averages, it's sitting under about $1 million for each tribunal. And just like the parties' legal costs, the moment that you adjust for inflation, it's not possible. Doesn't mean it's never going to change, right? But on the basis of the data, it was not possible to identify a meaningful increase in tribunal costs or decrease over time. So one of the charts that I got some help with my husband, bless his heart, on Boxing Day. Right? What did I do for Christmas holiday? I worked on this book, as Blake probably knows, but it lent itself to doing a really interesting infographic. And that's this. This is essentially a quartile distribution on the same scale of the different costs. It gives you a sense of the fat middle line, that's the median cost. And you can see the upper quartiles, the lower quartiles, and little dots are basically outliers. But it gives you a sense visually of the difference in spread. See how tightly and compressed and low the tribunal cost is as compared to the investor's cost, which has a broader dispersion, and the respondent's costs are fairly similar to the investor's costs, but with a slightly tighter distribution. So broad investor distribution, kind of a little bit tighter state distribution, but a very comparatively small cost for the tribunals. Everything's on the same scale. Now, I did indicate that the data is time-bound, and I understand that Jeffrey Commission might have been here, but unfortunately I don't think that he was able to make it. But in case he's live streaming, I want to give you a sense that I was actually very glad that different people like Jeffrey Commission and Matthew Hodgson were actually looking at costs as well. They unfortunately did not adjust for inflation or look at standard deviations, but it gave me a sense that even though my data was a little bit older, that the measures of central tendency were still there. So in other words, about $5.5 million to $6 million for investors, about $5 million or a little bit lower for state costs and tribunal expenses. Everybody's sitting comfortably under $1 million. But this is a lot of cash. I know I don't have that much in my retirement fund, that's for certain. To the extent that these costs are large and they matter, one would think that these would be addressed at a reasonably early stage, or that there is an opportunity to do so, because they're certainly not prohibited from doing so in the rules. But unfortunately, the data suggests, and this may also be why some of the ICSID reform focuses on that, tribunals that could have offered guidance at an early stage but chose not to. Substantive decisions tend to be made, nearly 96% of them, only at the final award, even though they could be done earlier. But what are tribunals doing when they do assess costs, particularly at the end? The overall pattern was that tribunals did not shift costs, right? This is the Lucy Reed point of all the parties are tending to pay your own way. And in the aggregate, that is in fact what the data showed. The pattern overall was that there was not some kind of cost shifting, whether to respondents or claimants. And in fact, the data did show when tribunals chose to shift costs, they were doing it in relatively equivalent proportions, both for both respondents and investors. But the data then are hiding something. This is like Philip Tetlock. You can look at the overall data, but when you peek under the rock, you need to parse it differently. Because people talk about costs follow the event, right? That there is a loser pays principle. And originally there had been a thesis proposed by Stefan Schill, namely that there's a unilateral cost shift, but it only operated to the benefit of investors. Some of my earlier research said that's nice, but I couldn't find that. However, this is why I ally myself with data, because the data now actually show that there's a statistically significant pattern. Namely, when investors win, they are reliably more likely to benefit from cost shifting. Whereas with state wins, they get the pay-as-you-go model, and they are not as equally likely to get the benefit of the loser pays rule. So we have a neutral rule that is disparately operating to the benefit of investors and not states. In terms of how do you justify these outcomes, in terms of the raw authority, they were actually not great at identifying the appropriate legal authority, better at offering some kind of a rationale. The good news is that they're getting better over time. But as my students in the room know, if you are going to do analysis for me on a final exam, I expect you to cite a rule and then develop that analysis. If the tribunals cannot get that done, one would think that they may not deserve an A, right? So what we've got is about 42% of tribunals that were offering any kind of authority for their final award. But again, the good news was over time, as the caseload was evolving, they were doing a little bit better at providing some kind of rationale. They were much better at providing the rationale. And the elements that they were focusing on were relative party success, equity, however defined, to say nothing of the discretion of tribunals. And this is why it's very interesting to see what ICSID has done with proposing its rules on cost shifting, because it's taking some of these natural baselines and incorporating them into the rule, hopefully to provide a cognitive nudge for tribunals to enhance the quality of their own decision making. These costs, however, aren't just linked to what do tribunals do with them. They also involve relationships with other variables. And I could talk about this for quite a while, but time is marching on, and I want to make sure we have a chance to hit a few highlights before I wrap up the presentation. In terms of the significant cost predictors, the only predictor that reliably predicted each type of cost was case length. It was bivariate and regression based. This is it. Everything else that there's a great deal of dispersion in terms of reliably predicting different costs. I encourage you, if you're interested, Chapter 6, Chapter 8, even Chapter 4. Right? These, you can check these out in greater detail. But I want to give you a visual, and these are also information graphics in the book that you can look at to give you a sense of it. The links with claimant legal cost. It was reliably linked with case length. And it's not just that it was linked. It was the practical significance of this was statistically large. It's the difference between saying I'm eating at a Burger King and a McDonald's and I'm eating at a Burger King and a 4-star or 3-star Michelin restaurant, right? It's one thing to say it's different. It's another thing to talk about the magnitude of this difference. So that link between time and the cost of claimant counsel was reliable and large. Similarly, tribunal costs and expensive, linked and reliably large. Respondent costs linked but medium size effect. But these are some of the biggest effects I've seen in my research, and I've been doing this for well over 10 years. There's a variety of other things that are linked, and I encourage you maybe to consider, for example, some of the regression modeling that I did. This is the regression model for the tribunal costs where case length was significant, and this was one of those very interesting times that amounts claimed were also linked to tribunal costs and expenses. And you could control case length and it would still be significant. You could control the presence of an energy dispute or lack of an energy dispute, and it would still be significant. And the experience of claimants' counsel was also statistically significant. But interestingly, not respondents' experience. It was one of those that moved around. There's something different going on with the cost of respondents' legal counsel. So what do we get when we add it up together for investment arbitration? The book talks about, on average, you're talking about 622 million, and that's 2011 adjusted numbers claimed. Amounts awarded on average 16 million. Pre-award interest, really hard to calculate because the tribunals don't do it consistently, 7.2. The money starts adding up. And then when you add up tribunal costs and counsel costs, and cost shifting and not knowing where it's going to go, it's one of those things that I have to say, we have to think about how to control time, we have to think about how to control costs, and we need to think about the value proposition that we are offering for the future of investment dispute settlement. Thank you.
Thank you, Susan. There's a lot on every one of those slides to chew on. Before we get into our panelists, what was the most surprising discovery you made when you did all this research? What really knocked you over?
I think there were probably two things. One thing was that a lot of stuff that I thought was going to change didn't. Right? I expected there to be changes, and so when I didn't find them, I said to my husband, because he's a physicist, so I talked to him a lot about the data to make sure I'm kind of keeping things in a very scientific perspective. And I said, I can't find anything changing. He said, well, that's part of the story. So that was actually a very interesting finding. The second was the unilateral cost shifting that operated reliably in investors' favor. That was surprising to me because it was a change, and it was also because I would like to think that it's not a kind of a de jure neutral rule is operating in a de facto discriminatory manner. So that's something to think about. I mean, there may be public international law norms that would justify that, and then I think that needs to be part of the conversation. But I think those would be the two things that really stuck with me.
Interesting. Mark, let's start with you. One of the things that strikes all of us, I think, is how immense all of these numbers are. But is there some kind of a frame that needs to be put over these? Is this really different from the kind of numbers we see in a big commercial dispute in civil litigation or even in commercial arbitration? Is this really an outlier?
First, let me answer the question very briefly. Then let me come back and make one or two remarks, and then I'll come back and answer the question more fully. There's really no way to tell whether commercial disputes, large-scale commercial disputes in national courts are relatively commensurate with these costs or not commensurate. I'll explain why I say that in a moment. But before I do, Susan, thank you for writing this book. I want to read you something you wrote, pages 337 to 338, because it really stuck with me. And indeed, I've already quoted it in public. As a form of knowledge acquisition, Data is in many senses superior to the substitution of political power, chance, instinct, personal opinion, intentional manipulation, or unrepresentative but emotionally sticky examples. Now, I too have been attracted by emotionally sticky examples that are undoubtedly unrepresentative. Thank you for the bucket of ice water. It's valuable for me, and I suspect it's valuable for many people in this community who are commenting on the world of investment treaty arbitration. And I mean that. Thank you. And Meg, thank you for that very flattering introduction, which I wrote. Now let's go back to your question, Meg. The reason why it's hard to answer is because the best data arguably would come from the United States courts. But we have a pay-as-you-go system in the U.S., which means the information about how much costs are, particularly PLC, is not found in the opinions. Because if it's a pay-as-you-go system, the courts are simply not addressing that question. There is less collection of data for court systems other than the United States, although the UK itself would be a very good source of data. And you will find expensive, large, complex cases. But looking at the data that Susan collected, there's something interesting. She reminded us of the importance of not taking the first-tier data, but continuing down the chain. If you turn, as I know all of you will when you buy this book, to page 279 or page 281, you'll see that she found interesting numbers distinguishing between energy disputes and non-energy disputes. For party legal expenses I'm focusing on now, in the context of state PLC, states for energy disputes averaged 4.7 million, or an inflation-adjusted 5.4 million. For non-energy disputes, 2.2 million, or on an inflation basis, 3 million. As she put it, the cost of an energy dispute for states on a PLC basis was roughly double. And that's worth thinking about. Second, for investors, there were again differences, although the data pool was smaller and therefore it's harder to come to any statistically significant numbers. For energy disputes, an average of 6.6 million, or on an inflation-adjusted basis, 7.6 million. For non-energy disputes, 3.4 million, or 3.9 million energy adjusted, but subject to variance and skewing because the number of awards that could be used to assess that question was on the small side. You also had differences for tribunal cost expenses. For energy, 783,000. Notice we're talking thousands now, not millions, or inflation-adjusted 895,000. For non-energy cases, 669,000, adjusted for inflation, 766,000. And wearing my self-interested hat as an arbitrator, I draw to your attention that is the sum of arbitrator plus institutional amounts. It is not just arbitrator costs and expenses. It is the tribunal costs and expenses. And obviously there may be differences when institutions are involved and when you have an ad hoc proceeding where there is no institution involved. And I note, by the way, her numbers for ad hocs included ad hoc arbitrations where an institution was brought in to administer the matter, but the rules were ad hoc. So that is an area where I'm confident Susan and her graduate students will have a lot of fun in the future digging even deeper. Bottom line, though, those are really expensive numbers. It's hard to tell whether national courts are equally expensive for complex disputes of a similar character because the data just is not there. So we're left with anecdotal stories, emotionally but, quote, sticky, unquote, examples. I will only say in that regard that back in the days when I was a transactional lawyer, my non-U.S. clients did not want to end up in U.S. courts because they thought it was pretty darn expensive.
Let's move to the question about state legal costs. And I think all the studies, including Susan's numbers, have shown us that for some reason state legal costs are generally less than the legal costs of investors. And Patrick, you were with the State Department for many years. Is there anything that you think intuitively explains that, or why would that be a consistent finding?
Yeah, well, first, I mean, Susan, this is absolutely tremendous. I mean, it is an incredible book. And I thought when I was starting to read it, I was like, okay, I have to read this book on arbitration costs, and I promised I'd do this event. And it's fantastic. Honestly, it really is. I'm not just trying to flog the book. It really is just amazing. And the thing that's amazing about it, in among many reasons, besides the fact that it represents a significant part of your life that we all watched you experience, is the questions that it brings up. You know, having the data in front of you, it not only helps test the assumptions, but it creates this kind of opening of intellectual curiosity about what underlies some of these data. And it's really just a wonderful thing, and I've really enjoyed it. So thank you. Second, thanks, Meg, for hosting us here. And it is probably the most intimidating thing in my life to follow Susan on costs and then Mark. So let me start and answer your question. When I first heard that this might be a question that was posed, I indulged briefly this fantasy that, well, the conventional wisdom on why states are given, why states' costs are less would hold, right? And that would be government lawyers cost less, right? So when I put in costs for my team, or when I was a line attorney, we were billed out at the DOJ rate, which meant that it's $150 or whatever an hour compared to $1,000 an hour or $800 an hour for counsel in the private sector. That's what drove states' costs, right? But that only works if the state is representing itself or involves mixed teams. So that couldn't be it. And then I thought, well, states are also less willing to pay, right? They're beholden to the public fisc. They are part of a more pluralist society. So that would, they'd cap things, and that would drive down costs. That, too, is belied in certain respects by the data. So, caps might be something that's driving things, right? Caps give certainty. You don't often see caps for claimants, right? So if a state says, jurisdiction, we're only willing to pay $1 million, everyone comes in there, that keeps costs down. But here's a couple ideas, and I'm brainstorming here because some of this isn't. I mean, it's just things that came to me. One, I think states are reactive more than claimants, right? Claimants have a burden of proof. They have an affirmative case to bring. States are reacting to that. They need not be possibly as creative in their response because they're just hitting back the ball that's sent over. Now, that's obviously not exactly correct, right? States are very creative in their defenses, but they're being reactive. Point one. Second, prestige. Prestige and repeat players. And the book on page 280, since Mark quoted, I'll quote too. I can do it too. 287 has a number of things to say about repeat players, but I don't think you can discount, and I don't know how this would be captured in the data, the prestige of representing a state and the willingness of firms, private actors, to cut rates or take a loss to represent a state. And you can see that in firms that the majority of their practice is representing claimants, and they have one, maybe two, vanguard states that I can't imagine they are charging the same rates to, and perhaps it's a loss for them. I wouldn't know. But I would say that there's some benefit and prestige to be able to do both, right? So there's that which can potentially drive down costs as well. And then the fact that there's no need for funding. And I know that there's some funders in the room, and I don't think, and I'll be the first to kind of cross the Rubicon and mention that funding, third-party funding, really is just a huge elephant in arbitration costs in the room. And what I mean by that is, you have funders who are offering a portfolio of funds to claimants that help drive costs in a certain way. There's a timing issue for funders, right? So if you reach a certain time threshold, they get paid more. And states just don't deal with those kinds of things. So those kinds of externalities, driving costs in one direction or another, are not things that states need to deal with. And in certain respects, states are a little bit more insulated by that. And then the last thing that I'd say, and I don't know this to be true or not, but from a repeat player perspective, one of the reasons why states that use competitive bidding processes, and sometimes those bidding processes are guided towards a repeat player, and there's a repeat player bias, right? Certain states, because they have political masters, need to demonstrate this is a GAR 30 firm, or this is they have this many chambers rankings, because if they lose, God forbid, they have a political to respond to, right? So there's some kind of benefit to having very well experienced firms. But another big driver on that is costs. And if you have a competitive bidding process, no matter how many awards you've won, if you're $3 million more than your next competitor, it's really hard for a state to bite on that, and that keeps costs lower too. So I'll stop there.
That's really Susan, did you find anything in particular in terms of a link in any direction between third-party funding and the cost of an arbitration? Because there's a lot of urban myths around that and a lot of discussion. I'm just wondering if there's any empirical data.
I think that the problem is, and this actually goes to ICSID rule reform, is having public information available about the funding. Right? So it's very hard to code something you can't see. So to the extent that there were literally only 2 or 3 awards in the data set that actually talked about third-party funding, I would be very wrong to make any kind of a leap. And that's a function of what tribunals can put in public awards or information that you can verify in a scientifically reliable way so that you can actually begin to explore those kinds of links. So to the extent that, for example, ICSID is trying to say, let's get some, not just for conflicts of interest in purposes, but to the extent that I can then get to code things, that becomes much, much easier to code, and then you can potentially track things in a very different way. I mean, Patrick, if I could also ask, because I've been wondering about this myself, it's about this competitive bidding process. It's not just about that, but some states have procurement obligations under their own national laws. So I can't help but wonder if that's also part of it. So maybe it doesn't bite on the kind of the third-party funding side, although there are cases where there has been funding available for respondent states, but maybe it's about kind of the national public regulation. I mean, I'm really fascinated about this because for respondent states, like it's not one of those variables where the cost is a reliable predictor, right? Is the counsel cost moves around. Sometimes it could look like it's significant, but the second you add another variable to control, it really changes. I mean, the only 2 predictive variables for respondent state costs, other than time, was what Mark already mentioned, namely the presence or lack of an energy dispute and the presence or absence of a separate opinion, right? And that was fascinating to me because then you could actually look at those cases with separate opinions that states paid reliably more for, and they were cases the states won, right? So it's kind of, for whatever reason, the extra money that they were paying in terms of advocacy had some kind of a return on investment, at least on the outcome side. So I thought that was very interesting. They were at least able to convince 2 members of the tribunal. Well, somebody wanted to dissent, right, and say something different. Third-party funding, harder to track when there's not that much data, but state respondent costs, it's a very tricky variable, and I think part of it is because there are so many different models of funding for states. So if you look at the variance in that middle bar, which is what the state's legal costs are, there are a lot of different states procuring counsel in many, many different ways with different national restrictions.
Let me just say one more thing, because I know I've spoken a lot already. But the states also have their version of portfolio funding. You know, I anecdotally, right, and sticky emotions. You know, well, if you come in at this number, you know, you have a chance, or you will get in our good graces for the next case, right? And part of the calculus when you're looking at representing a state versus representing a claimant, how many times is a claimant going to be a repeat player? Whereas if you get in the state's good graces, you know, maybe you bring your costs down so that you have, because volume is just as good as one big case, right? So,
interesting. Christina, one of the possibilities, or one of the things that's been discussed, is whether part of the issue is that we see costs, you know, 6 years later. And so nobody really is adding it all up as they go along. And that maybe having interim costs awards will slow down counsel and may well be a bit of a reality check for clients to be much more disciplined on their counsel about how fast are we racking up these costs and what's the cost benefit of each motion that we bring. Do you think there's anything to that?
So I think it's a really interesting idea. It's one that Susan touches upon in Chapter 9 of her book. It's the last chapter on the way forward, which is more perspective in nature. And she's right to point out that there's certain advantages by empowering tribunals to make interim decisions on costs. For example, it may encourage more constructive behavior amongst the parties. It gives a indication or guidance to the parties as well as to how tribunals will ultimately exercise their discretion on costs. And it seems that it's also gained traction in ICSID. It's one of the proposals that it has put forward amongst its package of amendments to the arbitration rules. Rule 50.2 provides that the tribunal may make interim decisions on costs of any part of the proceeding at any time. So I think there is a potential to, you know, benefit from this sort of measure, but at the same time, I think we should also be mindful of the potential drawbacks. And I see a few. The first is when, on the flip side, these decisions are made perhaps too early in the process, when tribunals have a very narrow slice of the case. And this is, you know, upfront when they're perhaps making a determination on jurisdiction if the case has been bifurcated, or if they've been tasked with deciding a preliminary objection based on the case lacking or the claim lacking manifest merits. So at this point, tribunals don't really have for obvious reasons, a very good understanding of the factual complexity of the case or the merits or weaknesses of each party's position. So I think there's a potential to perhaps impose a determination on costs at a premature stage of the proceedings. There's another drawback whereby arbitrators are potentially exposed to accusations or potentially even challenges on the basis that they've prejudged some of the issues in the case. And that can potentially slow down a proceeding when the remaining arbitrators or the chairman of the administrative council has to decide on these challenges. Similarly, I think there's also a potential for creating difficulties for economically disadvantaged investors who may face trouble in both paying their legal expenses and putting forward funds to cover the cost of a decision on costs. And in the meantime, it may lead to a suspension of the case or possibly the discontinuance. On the other hand, I think that there's also a potential risk for states who may not be quite as experienced in ISDS to potentially misread a decision on costs as an indication of the tribunal's views on the strengths of their defenses. And it may in turn lead to states making settlements for otherwise unmeritorious claims. So I think you have to make a case-by-case determination on whether it's appropriate in the circumstances. And I think there are circumstances where it could potentially be useful. For example, in document production, if the parties have gone through a protracted, costly discovery process, and most of the delays can be attributed to the conduct of one of the parties, it may actually be an appropriate time to issue an interim decision on costs. But if the objective is to increase transparency and predictability, there are other, I think, options available to the parties. For example, deciding up front at the outset in the first procedural order to decide on how the basis on which cost decisions will be made. And I think there's value in that. It also pays respect to one of the overarching objectives of investment arbitration or arbitration in general, which is to respect party autonomy. So I think interim awards or interim decisions on costs are one of many possible tools that are open to both parties and tribunals.
Susan, did any of the numbers tell you anything one way or the other about interim cost awards?
Yeah, I think I know these slides were a lot to take in. I had a chair. It was like a Sophie's Choice, choosing between my favorite children. It really was quite difficult. I don't think I think it was up front. No, maybe. Okay. So I think what was interesting to me is I very much take Christina's point out. Like, there are many different times and places at which tribunals could address costs. And if there's not a default in the rule, I think PO number 1, like procedural order number 1, is a really great place to do it, because then you're sending that signal. If you are, if we're considering party misconduct, we can tell you ex ante that is definitely on our radar. So be warned if you engage in some nefarious activity, what have you. So in a perfect world, I would like to see that. Unfortunately, that is not part of what I was able to study. So what I was able to study was the interim awards, like the jurisdictional awards. And I just want to flag like how basically that we tried to do this coding. And I really wish some of the coders were here, because I remember the conversations that we had. We were just looking for something like, did you even talk about a cost, right? Did you even talk about the standards that you might use, or reference a procedural order somewhere that indicated that you were willing to entertain ex ante baselines about costs or cost shifting or lack thereof? And there was not a lot there. So this is why, in the non-final awards, we were getting a lot of no cost references at all. And if we got anything, it was literally one sentence. That's how you get the 70%. We're reserving costs, and that's pretty much all the content analysis would say. So to the extent that, I think we're in agreement that having a lot of clarity in advance could be very useful for expectation management and litigation planning. But the question is where to do it most effectively. Unfortunately, for better or worse, the content analysis I was able to see was tribunals either say nothing at all, nothing, or they might just punt with a sentence. So when I see that kind of an information vortex, it makes me think some kind of a nudge is useful. Right? Which is why I'm very intrigued again with ICSID's approach of saying, let's put the nudge in the rules.
Before we go on here, I'm wondering if there are questions in the audience or anything people would like to ask from the audience. Martina, start us off.
Thank you, and thank you, Susan, for this is super interesting. It makes me really want to read the full book. I do have a question about the unilateral cost shifting that you mentioned, that there are more cost shifting in favor of claimants and less for states. And I wanted to ask about if you had made a distinction between the different types of awards that you can have, because the state can prevail in two ways, either on jurisdiction or on the merits. And usually if it's on the merits, it might have gone through a jurisdictional phase and lost. So you could have a win and a loss in the final result for the state.
Right. So basically the way this coded a win was, an investor win was I got $1 or more. Right. So it's a very raw, basic measure of outcome. I think it's chapter 4 has a very detailed analysis on a phase-by-phase assessment to kind of look at where people were winning and losing. And it's very interesting, but we weren't looking at that so much in connection with cost. So this is because of the nature of the test, it's a categorical test. So you can look at win and losing, right, in a did I get anything at all? And this figure doesn't include the settlement and discontinued category, but if I recall correctly, I think I had a slide I deleted because I thought there were too many. We actually did also take a look at settlements and discontinuances, and it was kind of operating in a little bit of a more equal way, but this is just a very blunt measure. It is one way of looking at outcome, and it doesn't look specifically at phases, but the bottom line is that the states were much better at getting mixed results at the merits phase, right? So it's kind of like a shifting scale. Investors were pretty good. I think the data was jurisdictionally, irrespective of how the case went. Investors usually got, I think, around 75% win rate for jurisdictional issues as a slice. And then merits were a little bit more mixed. And then the states in the damages phase were much better at getting the damages reduced. Right, so that's kind of a big picture breakdown, but please refer to the book. I basically wrote it so that if I ever had a question, I could go look at it, right? But in terms of this metric, it was just a very blunt win-lose ratio. And again, Wendy Miles has written a little bit about this and kind of why a one-way cost-shifting rule might be justified. It's actually very interesting. She says these are states being sued. There's a public international law value to be served. And to the extent that Chorzo Factory talks about you have to provide full compensation, John Gotanda would probably say this too. Maybe we do need a one-way cost-shifting rule that benefits investors to make them whole. Right? That's the policy and normative argument. I can see that argument. I could also see counter arguments because that's the way I think. But the bottom line is this is where we are, and I think we have to figure out as a community, and especially the stakeholders who hold the pen, namely the states, they have to figure out if they like that baseline.
Go on ahead, Mark.
I'll just speak up. Susan, first of all, congratulations on the book.
Thank you.
Bravo on all the work done. I look forward to reading it. I'm wondering if the data suggests, or what other considerations might suggest, that cost-shifting decisions be moved from the tribunal to some other body. For example, ICSID could have a standing committee of distinguished investment arbitrators who would rotate in their responsibilities from one case to another to handle cost applications. And they could do so, for example, on a set of criteria, which would be like sentencing guidelines. You committee are to consider A, B, C, D, and E, and the parties will submit to you based on that framework. And that would facilitate, for example, interim cost awards without consequences for the sitting tribunal thinking about how they're perceived by the parties that they're being accused of predisposition or whatever. I wonder how you and panelists
I'd love to know what Christina thinks.
That's actually something I was planning on discussing. I'm glad someone else put it out there because before something's done, it sounds crazy. But actually, I think that's a really valid idea. And it's something that the ICC court does through their scrutiny of awards before they're issued. So I can develop it now or later.
Yeah, we can have this conversation because I do think it's a question of how do we achieve the goal that we're trying to do, namely how do we incentivize parties properly using the structures of rule of law that we have available to us. I mean, I worry a little bit that there's then a disconnection between the tribunal who's watching the party conduct and who can maybe have a longer term sense of what's really going on, because if the idea is to make sure you're not you're incentivizing parties to behave properly or potentially penalizing them from behaving improperly, because those are two different things, right? Incentivizing good behavior is not the same as punishing bad behavior. The folks who are most likely to understand the full scope of that nuance, they would be the tribunal, right? Because they're in the sand pit. And as the judge I used to clerk for said, I like playing in the dirt. Right, because then I get a full sense of what is going on. So I like the structural shift. I think it's a very interesting conversation to have. It also makes me worried if, by gaining the benefit of a non-arbitrator challenge, you're losing the interstitial feeling of what's really going on in terms of party conduct and what you may be trying to incentivize.
And just one more thing on the interstitial point, if I could just interject. I mean, part of the reason why costs are so powerful is in part attributable to the discretion that a tribunal has in awarding them. And there's obviously the point about counsel conduct. But anecdotally, it's part of the deliberations such that sometimes getting a cost award avoids a dissent. Sometimes getting a cost award reduces damages. Sometimes it's a bargaining chip.
Right.
And it's a bargaining chip that's very powerful for a tribunal, in part because of the discretion and because of that kind of interstitial quality that you just mentioned.
Yeah, this is also something I've probably about, I think it was 6 years ago, I was presenting at St. Gallen at a conference on costs. And to the extent that investment arbitration is becoming more legalized, a little bit more predictable with jurisprudence constance, costs are one of the only areas of pure discretion that's still available. So to the extent that you're trying to move a bubble, imagine you've got to solve a problem. You've got a bubble in a waterbed that you have to deal with it, and you have to figure out, where do I move that bubble so that I get a comfortable night's sleep? Costs are the only pocket of discretion that really lets you move things, to the extent that the rest of the system is becoming much more, Americanized, some might say, or judicialized, as others might say. I'm thinking Bob Hudek talked about the judicialization of international economic law. So to give away this one pocket of discretion, it has a benefit, but it has a cost.
Oh, we have another question here.
So one of the topics that comes to mind when thinking about arbitration costs is obviously access to justice. So I'm wondering if when you were collecting this data, you also took into consideration or thought about the different size of the investors and whether, because obviously not all investors that should have access to investment treaty arbitration are going to have a spare $8 million to spend on a case. And what are your thoughts on, after collecting this data, on the links between arbitration costs and access to justice when it comes to smaller or medium-sized investors?
Great. Thank you. That's Lorena Guzman-Diaz, ladies and gentlemen. She is thanked in the foreword because she did some amazing blue booking. So thanks very much for that question, Lorena. I'd say two things. The first is that I actually, although I didn't break it out in Chapter 6, there are places in Chapter 4 in particular, in the footnotes, if you're into that, where I did actually test to see, is there a difference in costs depending upon how you classify the investor. And I looked at the humans versus corporations, FT 500 entities or related entities or lack thereof. And when I was doing that, because my thesis was maybe I'd find something, but I didn't. So as Blake knows, what ended up dictating most of the second half of the book what were the variables that were kind of robust predictors or were kind of part of the literature and maybe could make a difference in the regression modeling. So investor after classifications, at least using the definitions that I was looking at, and I used about 3 or 4 different types, I couldn't really find major cost differences. It's kind of, it takes what it takes in a way for the dispute. But part of the reason that I actually started doing this work was I was very interested in access to justice, not just for investors, but also for states. And this is part of, I would like to think, one of my mea culpas, which Martina may remember. When I was practicing in London, I had a case against a developing country, and it was one of those cases that stuck with you. And Martina is nodding. And it made me think, we have contingency fees in the United States. Not all countries have contingency fees. That's actually very important to know. That is ethically and legally proper in the United States, and I think England and Wales permitted that in the last kind of 10, 15 years, but not every place does. So that gives some access to justice to investors. Third-party funding also provides access to justice for impecunious investors. But what about sovereign states who didn't have the internal repository or the capacity, or they were choosing, for example, the Attorney General of the Seychelles, they were choosing, one day they were in ICSID hearing in London, and then, 3 days later they were trying a murder trial back in the Seychelles, and it was the same Attorney General running the same case. I mean, that's a very difficult nut to crack. And it made me think, does he have access to justice? Does he have the materials that he needs? So I've been thinking about that for a very long time. And I think normatively what that means to me, and I talk about this in Chapter 9, is I think there's 2 critical things to think about. And Meg and I may agree to disagree on some of this, but I've always been very interested in some kind of model of a legal assistance center that's available for developing states. I had this pipe dream back in 2004 that why couldn't we have a law school clinic that actually provided or aided the assistance? It'd be a great training ground for students, and it would also potentially provide some really interesting access to justice for states who might not be able to get extra expertise for whatever reasons of internal constraints. And I think that's been floated in the past. It hasn't been successful, but to me that is an option that should remain within the zone of reasonable conversation. The other idea that I have is why not have a standing claims for small claims? So a small claims tribunal for small disputes where maybe we have expedited procedures. I mean, ICSID is doing a great job with its expedited rules, which may kind of be a de facto kind of, but it's not the same as having a small claims court. It's not the same as having a small claims body that regularizes dispute settlement so that the $8 million doesn't necessarily have to be paid by either party. Right, and it's a much easier process, but there will be costs to setting up even that solution. I think the general idea is no choice is going to be cost-free, and doing nothing is also not cost-free.
Yeah, Teddy, go on ahead.
Teddy Baldwin. First off, I don't know what you have against hedgehogs because they're very cute animals. But, putting that aside, I was struck by what you were talking about 75% of the jurisdictional challenges go into the favor of claimants. And I think if you take that figure and another figure you talked about today, or the correlation between the amount of time a proceeding has and the cost, that being the most direct correlation, and you take those 2 figures together, it would seem that perhaps it would counsel against bifurcation, meaning that when these cases are bifurcated and only 25% are won, and you look at the amount of extra time that goes into it, perhaps not only are claimants suffering as a result of bifurcation by the additional cost, but states too. So I wonder if you've looked at that or have any thoughts on that issue.
Yes, I've looked at that. It's very complicated, actually. So bifurcation, if you look at it in a really bivariate way, bifurcated cases cost more, a lot more, and they take a lot longer. But the irony is the second you control for case length, that difference goes away. So it's kind of, and I honestly don't know if it's the cart leading the horse, right? Is it the bifurcation that's causing it, or is it the nature of the case that's causing it? I don't know. So one of the things that's been fascinating to me to watch with ICSID rule development is they're taking a really nuanced approach to how to manage bifurcation issues. And the data to me suggests that makes sense. And I left out all the manifest disregard cases because A, there are not that many of them, and Michela Potesta has already done a really interesting content analysis of those early determinations. But if you then take the rest of the body of the awards and look at them, yeah, on one hand, bifurcation means you're spending more and you're taking longer. But if you then control, for the effective case length, the difference goes away. So I don't know what's driving it. I honestly don't. If I did, I would tell you.
I have a hypothesis for what's driving it.
I love hypotheses, right? Because then we're testing them to make sure we are
Here's
my
hypothesis.
Ready.
And I think you're going to see more bifurcation. And we'll see what the ICSID rules do to this, because I think they're a fascinating entry into this. But what I think is driving it is, in part, funders. Third-party funders, greater contingencies, greater risk on behalf of counsel. Because if you're funding a case in tranches and you're not releasing your merits amount until after the threshold questions on jurisdiction are finalized, then you fund the case through jurisdiction. You ask the claimant to make the decision that this case will be bifurcated. You kind of sniff around the edges on that because you don't want to let the state know that you're willing to bifurcate. And then, the question is, how much risk and how much the kind of investment of the investment is driving these decisions. And I think what you're seeing is a perversion on that, because it's not based on the strength of the jurisdictional claim necessarily. It's based on, well, I only want to release a certain amount of funds if I know we're getting to merits, for exactly the reason you said, because that's where the damages are. So I think you're going to probably see more bifurcation if third-party funding and legal contingencies continue to kind of increase as they are.
If I could just make one point about that, it's important to remember the dates for Susan's database. The great burst in third-party funding that we are seeing now occurs after the dates of the database.
No, I think that's right. Even without the burst, just to go back again, I said I wrote this so that I could always have something to go look at. Page 133 has a very easy to digest chart, figure 4.4. So the mean number of months to render a final award. In a non-bifurcated case, it's 37 months. In a bifurcated case, it's 53. Right? I know, and this is why I say it's a really tough nut to crack, because I'm trying to figure out, if I thought that there was a legitimate explanation for what was going on, I would absolutely offer it. One thing that I also think about was, and this was, I believe, Frauke Nischke, is Frauke here? No. So Frauke always asks me hard questions, which I adore. And one of the questions that she asked me when I was starting this generation of research was, have you started looking at the time from the date of the final hearing to when the tribunal actually renders its award? And to the extent that you're writing two awards, you have two potential pockets for kind of deliberative delay, which you have to have in order to write the award. Award writing is a very laborious process, and when you're talking about state responsibility, I think it's proper to spend time on that effort. The data did suggest overall, it's an overall data piece, is that tribunals can take between 9 and 10 months to render an award. Right? Whether it's a jurisdictional award, a merits award, a damage award. So to the extent that you've got bifurcation, you've got essentially two pockets of deliberative delay, which might be 9-10 months on average. That may also explain part of it. I don't think it explains all of it, because if you bifurcate and you bifurcate successfully, you're done, right? And then that's potentially faster. Then this is why I thought, what was it, the article, the BIS article that ICSID added in the most recent revision from March? I thought it was a very thoughtful way of trying to manage the potential variance that you get from bifurcation, because it may be your desire to bifurcate to spend money, to save time and money, and then you get what you wished for and it wasn't quite what you thought you were going to get.
Yes, we got a question there and then a question here. Go on ahead.
Hello. My question is, you found a very strong prediction that length over cost. And my concern is whether that's people are gonna read your book and gonna think, okay, well, the recipe then to contain cost is to shrink the length of the proceedings. Let's have very accelerated proceedings. But what if what's driving the cost is not the length, but the complexity of the case? And more complex cases take longer to decide. And in that case, if what we would do is to just compress the length of the proceedings without respect to the complexity of the case, we would end up with worse decisions because it would be forcing the arbitrators to rush through the proceeding and so on. So that's my question. Is there a measure that we could design of case complexity to try to explain that?
If you could design a reliable scientific measure for case complexity, I would love to know about it, right? Because measurement validity is the hardest thing in any scientific study. Are you really measuring what you want to measure? And this is why I'm a big fan of using multiple variables to measure, to just kind of cross-check to make sure you're thinking about it. And don't forget that different costs may have different drivers. I put back up the predictive model for tribunals, costs, and expenses, because this was something that was maybe one of those surprises. And maybe it also might be a function of the fact that ICSID does an hourly rate. So an hourly rate is going to be linked to potentially, higher costs if there's more effort invested. And so this was the tribunal's cost was one of the few places where amounts claimed was reliably predictive of a cost. And it was predictive of tribunals, even controlling for the effect of time. So in other words, if claimants were asking for more cash ex ante, the tribunals were going to expend more time and therefore theoretically more money, right, chasing that. So to the extent that claims are proxy for complexity, then maybe that's one way to do it. But I'm also not sure that actually works very well, right? So there's ways to undercut that argument. This is why if you want to join the process of trying to articulate variables so that we can add better measures, come and join my school bus, right? Because I think these are very interesting questions that are well worth asking, but trying to figure out how it turns. It may turn for one variable, but not another. Energy was predictive for respondent states, but not tribunals, not for investors' counsel. I mean, so that's why I said one of the big themes was that time was what predicted things. And the rest, it was a bit of a hodgepodge. And I do commend to you the tables because they're pretty easy to read. They look like this. Oh, what are the variables that you cared about? Are they predictive? Yes or no? That show you in pretty straightforward visuals what's really, or at least on the basis of the data, what appears to be going on. But to the extent that we can manage time in a way that is more likely to decrease cost, this is why I think the ICSID innovation, thank you, Meg, of the initial case management conference, which is a little bit different than the procedural order number one, may be an opportunity to force the parties in the same room and then get them to be a little bit more careful about how they're managing their own time and resources. And it may be because it's a bet the country or bet the company dispute that people need to go all in.
We had one question here and one question here, and then we'll do three short ones and wrap up. I think we try here. Well, you've got the mic. Go on ahead. And then we've got one person who's been very patient here.
Hi, Susan, and thank you for just summarizing all the findings for us and making it very interesting to read. The question that I have is whether the parsing of the cost is did in any way take into account, say, for instance, preliminary objection phases like the 41.5 ICSID rule? Do you have any data? And I'm thinking in terms of it's not quite bifurcation, but I see how that could eventually make some proceedings a little bit longer and therefore could influence costs.
Mm-hmm. No, I 100% understand that question. So in the data set, there were probably less than 10 cases that actually dealt with those. And so that's why I felt very uncomfortable adding those in, because they seemed to me a little bit special. So I said, look, again, Michela Potesta had done a pretty good contemporaneous analysis of those preliminary determinations and looking at costs and cost shifting. So I encourage you to look at that. But I tried to separate that out because it was A, highly unusual, and B, such a small subset that I was worried that that highly unusual, and I'm just going to say it, ICSID specific procedure may create a challenge comparing apples to apples.
And you had a question. Please go ahead.
Yeah, my question was about document production. I think that was touched upon very briefly when in the discussion about interim awards. I come from a civil law perspective, and in my experience as counsel, I work mostly with states, civil law states, and I know that's a big criticism that's rising as well, because document production is to some extent resembling more and more discovery in U.S. litigation. At least that's a myth. I don't know if that's really the case. And that's making case go longer at times, and that could be a driver of increased costs. So I'm wondering if there's any data on it, and whether that was actually data that you could analyze, maybe depending on whether there were very clear rules in procedural order number 1 trying to contain document production.
Right. So basically, that would have either gone into what I call the party behavior categories of deterring inappropriate behavior and encouraging appropriate behavior, right? So like good document production policies or smacking people's hands for engaging in nefarious behavior. My recollection, without delving specifically into those, and you can of course access the data set and check things out yourself if you are really excited about it. But my recollection, which can always be wrong unless I check the data, is that tribunals didn't talk so much about document production requests. They may have talked about failure to produce documents or nefarious behavior. I think one of the emotive, sticky ones that comes to mind is the Generation Ukraine case, where there was, I believe, a little bit of dumpster diving that was involved, and I think some Irish counsel who are one-shot players who I don't think ever came back to the community. I could be wrong about that, but that's one of the few times where the tribunals were specifically talking in an extensive way about that. What you often get is tribunals saying, oh, both parties were engaging in professional, appropriate conduct, and maybe there was a novel claim, which novelty is another thing to think about, but they won't get into the granular details. And there's actually, ironically then, how long do you want the cost awards to be? I mean, I often worry about this. If I'm asking tribunals to be more careful with costs, is that then going to increase the cost? Because the parties, especially under the ICSID rules, are going to be requiring cost submission, which has its own costs, and then tribunal deliberations on the separate point of cost may have its own costs. But in terms of the specific disclosure issues, it would be in either of those two variables, and it wasn't something that was regularly talked about to the best of my recollection. It usually was maybe some memorable client behavior that they wanted to use the cost stick to say thank you or reward or penalize.
Let's finish this with maybe 3 short questions with short answers from each of our panelists, and then we can continue. We'd be delighted for everybody to come and continue over a glass of wine. So, Patrick, to start with you, how do you get counsel to reduce their costs? You just give them less time to talk?
Well, you just gave me less time to talk. I mean, no, short answers on that question, which I think is a huge one. So, firstly, just to respond, like document production, right? So that's kind of the answer to your question is I think it's really for the tribunal in many respects to guide these things. So we'll hopefully have some interventions on that. Point 2 is what can counsel do? I've already talked about how contingency and more risk-based things are going to drive costs down, right? Because you need to be more efficient. I think that's something that we'll see over time. It's a little hard to in the ISDS space to impose time limits the way that some commercial arbitration institutions have done, because remember, this is arbitration without privity, and it's a totally different world in certain respects from a party autonomy perspective. But things that counsel can do, invest in AI. I think that will be a significant cost driver in the next 5 years on document production. And I think we need to, I don't know what the data would say, and I don't know how you measure this, Susan, but I think we need to probably give up the emotive stickiness of civil law societies think that this is an Americanization of investment arbitration. I have never once met a civil lawyer who, once they taste the joy of document production, don't want to see it all. And that includes tribunals, right? I mean, it's and then the last thing that I'll say, keeping it short, is perhaps, and now I'm, again, spitballing here, if counsel were to agree as a result of best practices or changes in the rules ex ante as part of the procedural order, that they empower the tribunal to impose costs throughout based on conduct, or something that is aspirational but ex ante, that the tribunal would then understand that they're not going to run into challenge, they're not going to run into annulment. It's a kind of insurance policy, but it becomes best practices for counsels to do ex ante. That could be helpful.
Interesting. Mark, how do you get tribunals to manage better if they're the cure here?
By controlling counsel. And I mean that because arbitrators are indeed reactive. Motion practice and document production are primary drivers of costs for party legal costs, and therefore for the amount of time that arbitrators spend on matters, which, by the way, anecdotally, arbitrators hate document production disputes. We really do. Achieving those objectives is much harder than it is to describe those objectives. Job owning at the very beginning, my personal experience is the job owning has a half-life of about 24 hours. And after that, counsel go back to doing whatever they thought they were doing. Interim cost awards, the imposition of an interim cost award is often a signal to that party that they may be running into heavy sledding on the ultimate result. That may or may not give rise to a challenge to me as an arbitrator. It will certainly give rise to obstructive behavior during the arbitration. So if I am asked to give an interim cost award, I have to think about that. Am I inviting future obstruction? And I also have to ask whether I'm issuing an order that I cannot compel compliance with. Because if that order is not performed, if the money I require to be paid is not paid, then what do I do? The tools available to an arbitrator in those circumstances are the kind of thing that often send signals about the results. The one thing I cannot do as an arbitrator is send the marshals to grab property. I have no marshals. Therefore, my tools of drawing a negative inference on a matter, that signals a result orientation, or issuing a double cost order. You're bad twice. That really helps a lot. Or proving that I have very few sanctions powers by issuing an order that's not going to be complied with. And that is something that arbitrators are quite reluctant to do. So it's easy enough for me to say that I should try to control counsel. Actually achieving that result is extraordinarily hard.
Last one, Christina. Expert witnesses, and in particular, the forensic or damages expert. That's easily $1 million in every case. Is that a cost that could easily be controlled?
So I haven't seen any empirical data on exactly how much, what portion of the PLCs are comprised of expert fees. I can only speak from personal experience, and they come a distant second to the lawyer's fees, quite frankly. And there's good reasons for that. I mean, these are very laborious tasks in testing, stress testing assumptions, and conducting research. If you're an investor's expert, you're building a model. If you're a respondent's expert, you're tearing down the model and potentially building it up again. So, you know, there are reasons why they are so costly. I think that we can't do away with experts in this field. Nearly every case will require some technical expertise, whether it's an accountant or an economist, construction expert, or a property surveyor. These are a skill set that many of us as lawyers don't possess. So that said, I do think there is a need to control experts. Two observations from the book that I found really interesting, Susan, is that you put a precise number to the fraction of damages that are actually awarded relative to the claim. I think, correct me if I'm wrong, it's something like 75% of investors are awarded roughly 30% or so of the amount claimed. That's extraordinary. And related to that, you found that the higher the amount of damages requested, the higher the arbitration costs. And I think that's a key takeaway, because in this age of, you know, these huge inflated claims. So I think there's a number of things we can do within the community to perhaps curb this trend that we're seeing, one of which, as you mentioned, states hold the mighty pen, right? So writing it into treaties that damages claims have to be reasonable. They have to be supported by data. Evidence is something quite critical. Tribunals making use of case management strategies in order to precisely identify the key issues in dispute, because otherwise the world is quite large and there are a handful of real value drivers in these cases. And finally, I think there's a role for institutions. Something we haven't talked about, but is something I've always thought of. ICSID, PCA, these institutions are, they're very capable counsel that are in the Secretariat. But what if we also had people with financial aptitude, with the qualifications to assess the financial aspects of these awards, to be sounding boards to tribunals? I think that there might be, you know, a role for institutions to play as well. So, I mean, to wrap up, I think that experts are highly critical in these cases, but I do think there needs to be some form of control to curb the size and to support the quantification of damages in these cases. And sometimes we don't see that.
It's like a standing expert within an institution to provide wing advice to a tribunal?
Well, I mean, just a body, so a group of counselors in a sense.
Mm-hmm.
I mean, the secretaries perform somewhat of those functions. They perform these research functions for some arbitrators. Why can't there be somebody who can say, can you explain to me what a discount rate is? Or, you know, what are the ways that we can measure country risk? Because this is a really viable way of doing things, you know? I just feel like there could be more support, potentially.
Good. All right. That's gotten us thinking. I want to thank all of the panelists and Susan in particular. And if you'll join me in thanking Susan and the panelists. And please, we invite you just go down the hall. We've got something to drink, something to eat. And for any of you who have not seen the new premises, we would be thrilled to show you around. So thank you for coming tonight, and please join us if you have some time to have a drink. Thank you.
Do you think that's okay?